much does it usually cost to form an LLC?
It depends. It depends on how complex the relationship is. Obviously, if there's 10 people involved in it, you're going to have to draft an operating agreement which reflects that.
And so that's then legal fees to your lawyer who's drafting that document.
Yeah.
Okay.
And then it's the filing fees are about $100.
Okay.
It's not that expensive for the filing fees. It really, but the value, the investment that you're making up front really is worth it. And if you don't have the money, that's what I tell people is, if you don't have the money to hire a lawyer, like a real lawyer, not a LegalZoom, but a real lawyer, to protect your assets, you probably don't have assets that are necessary to protect, right? So you may not even need to do it. You may just go as a sole proprietorship, get some insurance, and you're good to go.
I think on the low end for single member LLC, about $400.
On LegalZoom?
Yes,
yeah, that sounds about right.
I've seen it up to about almost $2,000, roughly in that ballpark.
Yeah, I mean, I know lawyers who charge $5,000 to do a 2-member LLC. I mean, not
Is that you?
I have a friend.
My own firm did, but not my new firm. On to corporations, the big daddy. All right, so corporations are their own entity. They are recognized by the government as a separate entity from those who own it. They now have individual rights where they can donate to political campaigns as if they were human beings. So the pros are that you have limited liability for business debts and legal claims. Very strong limited liability. So you are pretty well protected if you are the owner of a corporation. It's very hard to what is called pierce the corporate veil, which is if you do something that's so egregious that it's really personal liability, there's ways that they can come get you, but it's really rare. There is a separate legal and tax entity from owners, so you have this separate entity, which venture capitalists and angel investors prefer. And I'll kind of talk a little bit more about why they prefer it, but in the event that you're going to take on VC or angel money, a corporation is probably the entity you're going to end up with, ultimately. Maybe not initially, but ultimately. Now the cons are that there's legal costs to form this. This is much more expensive because the nature of the corporation formation documents is much more elaborate because you have to deal with shareholders and organizational CEOs and CFOs and presidents and things like that. It just takes a lot more time to really make sure that everything is set up properly. The same minimum state tax, so it's even if you generate $0, you're still going to pay $800 a year minimum to the franchise tax board. Another con is you have to file a separate tax return. So that means you have to hire an accountant for this entity, and then whatever the profits that go through dictates your personal tax liability. Yes.
So even if you're a privately held corporation, do you still have shareholders?
Not always. No. You make that decision. You can be a privately held and own all the equity, or you can have shareholders as well. Shareholders, what you're talking about is more publicly traded company versus privately held. So you can have shares of stock that aren't publicly traded. Then there needs to be a way that the public can find me, find out who I am, who Aesthetic Legal really is. So if you file, if you have a sole proprietorship or a partnership and you're operating as your own business name, your own personal name, you're okay. You don't need to do anything. It's only when you create this new name. If you have an LLC or a corporation, you've already filed that name, right? So if I was a corporation, I'd be Aesthetic Legal Inc. There'd be a public record of who I am and how to find me in the event something goes wrong. So I wouldn't need to do a fictitious business name. But for partnerships and sole practitioners, you have to file within the county recorder in which the business is located. So in Los Angeles, you go to Los Angeles County Recorder. I think it's about $100 for the full service. it's a one-page form. You fill it out. It just says who you are, your address, your DBA name. They file it, and then they publish it in a magazine or in a newspaper for 4 consecutive weeks. Then you get your certificate, and you're good to go. It's very simple. I think it's good for 5 years or 10 years, and you can just easily renew it. All right, so the intellectual property, as I said, this is really the heart of a creative business, a tech company. This is really the value of your business. Okay, so we're talking about copyright, trademark, and patent. And there is overlap between these 3 areas, but they also are very distinctly different. So copyright protects original works of authorship fixed in a tangible medium of expression. I have a story that I'm going to kind of go through that's going to explain exactly what that means and how it's relevant. But it applies to literary works, audiovisual works, pictorial, graphic works. It includes computer code, audiovisual, multimedia, things like that. Trademark protects brand names and services. So it's a little bit different. There is overlap. There's copyright in trademarked logos, and there's trademark implications into copyrighted artwork. But they're different. Patent, for tech companies especially, is very important because it protects the scientific process or design. It doesn't give the holder of the patent the right to create. What it does is it gives the holder of the patent the right to prevent and prohibit others from creating whatever is established by the patent. Okay? I'm going to talk through all these. Okay, copyright is the first piece that we're going to talk about. So copyright is vested at the moment the work is fixed in a tangible medium. What does that mean? It means when a graphic designer puts his pencil down, or stops writing the code, the line of computer code, or the graphic designer finishes her logo design. That's considered fixed in a tangible medium. It's a very liberal definition. Even if it's fixed for just a split second, it's considered fixed. So anything that's like dance, choreography is not fixed. Now if you film it, then it's fixed on the camera, but just public performance is not fixed. There's nothing to capture it. So there's no copyright protection to dance other than if it's choreographed and filmed. Copyright, what is copyright? Copyright is the right to reproduce, distribute, display, perform, and create derivative works. And the copyright owner exclusively controls who can reproduce, distribute, display, perform, or create derivative works. All right, so copyright, anytime that you are creating something for your creative business, your tech business, registration of the copyright is essential because it provides you with statutory remedies that are only available if you register the copyright. Copyright.gov is the online registration site. It's $35. It's the best insurance policy you will ever purchase because of 2 distinct statutory remedies. Number 1, the right to recover statutory damages. Usually in a copyright infringement or any kind of lawsuit, you have to prove your damages so that the court knows how much to award you. If you have a registered copyright, you do not have to prove damages, which is very difficult, especially in a copyright infringement claim, because you have to prove how much money they made, and they get to back out all of their costs. And especially in the motion picture industry, they've never made a penny on any movie ever. Just so you know, that's how the accounting works. So statutory damages are dependent upon how willful the infringement was. So if a judge determines that the person who stole your work acted willfully, they knew what they were doing, they stole it. It doesn't matter, they could make $1. They could still be liable for up to $150,000. Secondly, attorney's fees. With a registered copyright, you have the ability to recover your own attorney's fees. So the other side, if they lose, they have to pay for your attorney's fees. What that does is, two things. Number 1, it moves these types of disputes quickly towards resolution because no one wants to risk hundreds of thousands of dollars of legal fees. Secondly, it gives you the ability to go to an attorney who will take this on a contingency fee basis. So you don't have to go out of pocket. You don't have to write a check for $50,000 for an attorney to bring a lawsuit. You can say, I have a registered copyright. They know that they're going to get their attorney's fees, so they'll take it on a contingency fee. Big hammers. And copyright is important because whatever you create, it lasts. That copyright protects that work for the life of the author for 70 years. That's a long time. There's a lot of value that can be generated in 100, 120, 130 years, right? Now, most issues with copyright arise with the separation of the original work and the copyright. Now, in business, you're going to hire people to work for you. You're going to hire a coder to come in and code. You're going to hire a graphic designer to design your logo. You're going to hire a website designer to design your website. Whatever it is, you're hiring them. Now, they may be employees, and if they are employees, by virtue of the employee-employer relationship, you are going to own the copyright in whatever they create, as long as they're creating it in the scope of their employment. But most disputes occur, and most problems arise when it's not an employee-employer relationship. It's a handshake deal. It's an independent contractor. It's hey, do this for me and I'll pay you some money. Okay? So, there's the perfect example of this, how I will explain the difference between ownership of the work. So a final work, a final logo, let's say, I own it, right? Somebody created it for me and I paid them for it and I have it. I have the hard drive, I own it, I'm gonna put it on all my products, I'm gonna sell it, right? It's mine. That is a personal property right, okay? Because I own the original. The copyright is an intellectual property. It is not uncommon to own the original work and have no right to the underlying intellectual property to the work. And that's problematic. Because if you remember, the owner of the copyright has the sole and exclusive right to permit who copies it, distributes it, reproduces it. So if you're going to put it on 5 million cans of coconut water, and you don't own the copyright, you only own the file, you could be in some serious problems.
So is the copyright still with the artist who made it?
The artist, whoever fixed it in a tangible medium. Okay? So, I'm going to give you an example that kind of clarifies this really, really succinctly. Last year, Oscars. Ellen went into the crowd, she took her camera into the crowd, she took that selfie, right, with all the movie stars. And at the last minute, if you remember, Bradley Cooper grabbed the camera out of her hand. And he pushed the button to take the picture, right? So Ellen owned the phone. She owned the file that was stored on the phone of the picture. She paid for all the services for the phone. But Bradley
technically
Cooper
his.
fixed it in a tangible medium. Okay? Bradley Cooper is the copyright owner in the image. Even though she owns the image, it's on her phone, she paid for it, it all belongs to her. So when she then immediately tweeted it out on her Twitter, I think it's still the highest, most popular retweet in the history of Twitter, she committed copyright infringement. Okay? Now, obviously Bradley Cooper didn't sue her because they're movie stars, but we don't live in the movie star world. We live in the real world, where there could have been significant liability for somebody who owned an original work to distribute it, and yet they had no ownership interest in the copyright. Okay? So it's imperative.
Take your own selfies at all times.
Yeah.
Always
Press the button.
Always. Like
All the
for
chamber
example,
stuff belongs to me.
It does. Although in the scope of your employment, there's probably I can make an argument. So
I don't want
when someone creates something of intellectual property for you, you hire somebody in your creative business, it is imperative that part of the process is to obtain the copyright ownership in whatever they're creating. Otherwise, it's useless. Okay?
How do you do that?
I'll tell you.
Thank you.
I don't mean to beat a dead horse, but just to clarify. So what you're saying is, at that point, if this phone were grabbed by someone else, even though it's my phone, they just press the button. That's
That image is
that is theirs. But what you're saying is, in the real world, for example, if you bring someone in and they're using your equipment, like your computer equipment, to do artwork, that you're saying the parallel here, the lesson here is not don't let someone grab your phone. The lesson is, if you've got equipment, even though it's on your equipment in your property, you know, you're paying for everything, the rent, da 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 da. If they're sitting down and they're creating the artwork, how are you saying to resolve that?
Well, I'm going to get to that.
Oh, okay.
But yes,
Okay.
you are absolutely correct in
Okay.
that. And
Okay.
it's directly
Right. Right.
it's the same set of facts. I
Right.
mean, regardless of where they're creating it,
Right.
if they're not an employee,
Right.
they create it. Yes.
I noticed that like in aerospace companies I used to work with, there's non-disclosures where you have to.
Yeah. So I'm going to talk about that. But yes, very good point. Here's a great thing about copyright law and about copyright. It can only be transferred in a written document. Okay? Good and bad. It's usually to the detriment of the artist, but in this situation it's actually to the benefit of the artist. So there are three ways really, to transfer the copyright. Work for hire agreement, an assignment agreement. Wait, I may have. Oh, we'll come back. Work for hire agreement, assignment agreement, or a license agreement. Okay, a work for hire agreement is language that's in the U.S. Copyright Act, and it identifies situations where you hire somebody who's not an employee to create something for you, and as a result, you obtain the copyright. Okay, and I'm going to kind of break these down a little bit later in terms of the licensing, but the copyright assignment is a complete assignment of the copyright. So the artist owns it and then assigns it. And there are issues with term and termination of transfer that I'll talk about because they differ, and you have to make a decision kind of which one you want to go with. And then a license agreement, which is is a limited transfer. So it's a limited transfer for a period of time, or for a number of units, or for a specific use. And those are negotiated, and I'll talk a little bit more about those. So in the event you hire somebody, you don't have a written agreement, they can actually prohibit you from using what they created. So you can pay them. You know, a logo is a perfect example. You hire a graphic designer to create a logo for you. They give it to you on a file. You pay them. They go their merry way. Your logo becomes iconic. It's on everything. They can come back and say, hey, I own the copyright in that. I'm going to sue you now because you've made so much money with that logo, and you are in a bad position. Now, there are arguments of implied license, but once you get to that point, you've already lost. I mean, you're going to spend all your money on lawyers trying to fight that argument. So it's just better at this juncture, if you're going to hire somebody to create anything for you, have to have a work for hire agreement, a copyright assignment agreement, those two. Licenses are a little bit different, but those two. All right, let's go to trademark. All right, so the trademark, this is the symbol for a common law trademark. This is a registered trademark. In order to use this symbol, you have to have registered your trademark with the United States Patent and Trademark Office. Okay? So what is a trademark? A trademark provides exclusive right to identify goods or services with a brand name. It can be renewed indefinitely. So as long as you're using it in commerce, using it in business, you can continue to renew it, and it will go on as long as you're using it. Trademarks can be one or a combination of words, letters, and numerals. They can consist of drawings, symbols, three-dimensional signs, audible signs such as music or vocal sounds, fragrances, or colors that are used as distinguishing features. I'm going to give you some examples that
You
will
can
open your
trademark a
eyes to that.
fragrance?
Fragrance, yeah.
How do you find out someone is using your fragrance?
It's the
You smell similar.
well, yeah, that's really, if you create, the knockoff perfumes,
Yeah.
that was where that came from,
Oh, how
right?
weird.
So you're making a generic cologne that's supposed to smell like something, but if they have a registered trademark in that sound, they can actually prohibit the knockoff from creating something that is identifiable, because that's what they're trying to sell, right? And then in terms of your business, so this has to do with your business name, your logo, catchphrases, and things like that you use in business. Before selecting the name, you need to do a due diligence search. So this kind of ties to back to the fictitious business name. USPTO records, you can do a search, do a Google search. Obviously, obtaining the website with that name is a good first start. If you own that website, the likelihood is that there's not going to be a big business that's already using that name because they would have secured it before you, but it's not always the case. There are small regional companies that are using the same name across the country. All right, so here is a brand logo in a bottle shape. You have the registered trademark. So Coca-Cola has the trademark in that name. The color, the font, the layout of the whole thing. There's a trademark. You can't create anything that would create a likelihood of confusion. That's the standard for trademark infringement. But Coke also has a trademark in the shape of the bottle, the silhouette. There's a trademark in that because when you see that, you know that that's a Coke bottle, right? It's an identifying characteristic. Intel. So they have a registered trademark in their name, and this is going to sound familiar. They have a trademark in that sound because it identifies their product. It's so closely tied to Intel that they obtained a trademark for that sound. Everyone good?
Yes.
All right. Employment independent contractor agreements. Okay, this has to do with when you are hiring somebody to do work for you, to create something for you. Okay? This has to do I'm going to only talk about this in the sense of creation of intellectual property because the key is to own the copyright, right? Because you have to. That's the only value you have. So, as I said earlier, there's a work for hire agreement or a copyright assignment agreement. The work for hire agreement works in that you hire them, they're not an employee, but they agree in writing that it's a work for hire, work made for hire. It's a term set forth in the Copyright Act. What it says is that they're an employee, even though they're not an employee. Only for the purpose of the copyright transfer are they an employee, but every other reason they're not an employee. If you remember, the term of the copyright for, if I was to create it myself, life of the author plus 70 years. In a work for hire agreement, the term of the copyright will last 95 years from first publication or 120 years from creation, whichever is shorter. So the term is different because life of the author plus 70, 120 years from creation, those could be, even to the same author, it could be completely divergent. You don't know which one. But you have to keep in mind that that's how it applies in terms of work made for hire. So if you guys, here's my contact information. I have cards up here also if you want them. If you have questions, email me, call me. Yes?
My question is, if you have retained a patent attorney and you feel the invoicing and the billing is going farther than you expected, that's a good way to respectfully ask them to show you what they're doing.
Just that way.
Say,
Yeah, you can just say I'm a little concerned with the bills. I was not anticipating this.
yeah.
Can you give me some ideas as to why this is so much more than I was anticipating? And they should justify it. They should be able to justify it. Thank you.
All right, are we
Welcome.
good?
Good?
Well, thank you very, very much, Matthew.
Thank you.
You did a lovely, lovely job. I think many of us are going to be taking your card and finding follow-up questions that we would like to contact you about. And I just wanted to say thank you very, very much for joining us at LAX Coworking. And hopefully this video will go somewhere and be tangible and be a thing. I don't even know.
Can we reproduce